to DDM Morning Show. I am Tosh Raphael, joined by DDM News analyst Ibrahim Omawase. Brian, if you're there, good morning.
Good morning, Mr. Tuchuko Raphael. It's a pleasure.
Okay. Well, Nigeria's justice system is at a critical crossroads, facing unprecedented challenges from delayed court cases to widespread public distrust. Recent sharp criticisms from NBA President Ifeanyi Nrialike, who has slammed the Supreme Court as the worst since democracy, highlights the growing crisis within our judiciary. Now, add to this the ongoing show-reasonable legal saga involving claims of defamation and cyberbullying that have gripped public attention alongside urgent calls for electoral reform to strengthen our democracy. Now, to help us navigate these complex legal issues and understand their implications for Nigeria's future, we have with us Ifeanyi Nrialike, a distinguished legal practitioner, consultant, and public commentator renowned for his expertise on Nigeria's legal landscape. Glad to have you, Mr. Nrialike.
Thank you. You are welcome.
All right. Now, the NBA president said the present judicial system is the worst since the advent of democracy in Nigeria. Now, people who did not witness past court systems would ask, what were the values held by the past systems which are non-existent today?
Okay, good morning, and thank you for having me. But I listened to the speech of the president of NBA, Mazi Ifeanyi Nrialike, SAN. I did not think that he said that the present judiciary is the worst in the history of Nigerian judicial system since the advent of the democracy in this Fourth Republic. Actually, he raised certain concerns. He raised certain concerns about delivery of judicial system in the country, and that it is very poor, and that judiciary is no longer becoming the last hope of the common man by virtue of the fact that the administration of justice is becoming very slow and sluggish. And he gave certain examples. Taking, for instance, when emergency rule was declared in Rivers State, and there is a matter in court before the Supreme Court to decide whether the president can unilaterally declare state of emergency in Rivers State, and it was not taken. And he equally drew reference to when a similar situation happened during the Obasanjo era, when state of emergency was equally declared in Plateau State, and that particular pronouncement, even when it went to court, that it took over 2 years after the state of emergency has ended and the governor reinstated before it was determined by the Supreme Court. And even at that, no definite pronouncement was made. He now said that there is need for certainty so that we can actually know, Nigerians can actually know whether it is proper in the manner that state of emergency is being declared without following the constitutional requirement as provided in the 1999 Constitution. He equally berated certain aspects, particularly the favoritism in the manner which judicial appointments are made, and how litigation-minded lawyers are not even incorporated into being considered for appointment as judges, and that it has equally eroded the quality of judgments that are being delivered by the Nigerian judicial system.
Right, thank you for highlighting some of the things
that the judiciary is the worst. He said that there is room for improvement, from what I understand. And he clearly stated that there is a perception that currently the judicial system is not working, and that perception is better than reality. When at times you say that you go to the court to seek justice, and you will stay years without getting the justice.
That is justice delayed, according to him, justice denied. And
exactly.
Yes, even another example is the Nnamdi Kanu's case, which has lingered for years now. So, given recent controversial rulings, the one you mentioned, the delayed River State emergency appeal, do you think the judiciary has lost its independence today?
There is an effort. You know, the problem of judiciary cannot be separated from the problem we have in Nigeria. We all know that there is a problem in the country, and the judiciary does not operate in isolation. So to the common man, I don't think that the judiciary has lost its independence. But the truth about it is that it is not living up to the expectations of Nigerians to a very large extent. And just like I said at my introduction, there is still room for improvement. The manner of justice delivery system, particularly in very sensitive cases, have left so much to be desired. And it is because of that that we are talking about perception. At times, the reality may not be exactly what people are seeing, because the perception, more often than not, overshadows the reality as it concerns the dispensation of justice. Unlike in the past, where you can see judicial pronouncements that were very fearless, nowadays, so many things are happening, particularly when you look at the political system. It will look as if the judiciary is always giving pat on the back to all our corrupt politicians who come into power through corrupt means. And the truth about it is that if you come in through a corrupt means, there is no how you can make the system better, because a corrupt product will always corrupt the system. And that is why it looks, because take for instance, so many governorship elections where people are quarreling about the manner of emergence of the governors and even other elective positions. Virtually all of them are returned as duly elected. And we all know that
Mr.
what we
Nrialike, are
see,
you still there?
yes, and we all know that what we see during the elections and what the court pronounces, they are entirely two different things. So that is why it is looking as if not so much development is made in the administration of justice in the present day Nigerian democratic system.
What do you think about the process of recruiting or appointing judges? The judicial appointments were described as two man, no man in quote, and in-house centric. So how does this system impact public confidence? And what reforms can ensure meritocracy and transparency, in the matter of recruitment of judges or appointment of judges?
The truth about it is that the manner of appointment of judges leaves so much to be desired. And you can rightly see, because nowadays, for you to be appointed as a judge, it is either you have a godfather politician, or that you are working in a place that can easily make it possible for you to be appointed. There are certain persons, like the time Justice Okuta was appointed a judge, from the story he told, which I read in the papers, he said that he was on his way traveling to another place. He was not even consulted. They just named him as a judge of the High Court. And that is when, on the basis of recommendation, high recommendation, people are appointed judges. But nowadays, there is nothing like that. And like the president of NBA said, there is need for greater transparency in the appointment of judges. He even opined that the justices of the courts have to go through an examination during which the result will be released within 6 hours. And the essence of releasing the result within 6 hours is to eliminate corruption, because the more you stay in releasing the result, the greater interference in the marking scheme. And that if that is done with so many other options that he has given, that to a very large extent, the quality of potential judges that will come through that particular process will be higher. It will now encourage very, very sound and erudite minds to come in. And he equally complained that, just like I said earlier, the situation of not appointing practicing lawyers. You know, at times, as a practicing lawyer, you become frustrated when the judges are not understanding the judges are not understanding what we are trying to convey. And so many decisions that can easily be taken are adjourned, and so many things that may be happening because of lack of that passion. Because if you have been on the side, if you are not a practicing lawyer, there are certain things about practice that you may not understand, particularly more so the passion that goes with it, and the certain other things that have been seen. When things are going wrong, a judge is supposed to take very, very, very make drastic decisions. But more often than not, these things are not done. And that is why it is looking as if the manner of appointment of judges has so much room to be desired.
All right. What are your thoughts about digital reforms in the Nigerian judiciary? Do you believe Nigeria's courts have adequate infrastructure and technology to implement these digital reforms immediately? And what challenges stand in the way?
The only challenge we have, and this is the same challenge we have with every other thing, is corruption. Apart from it, we are ready, very, very ready. You just need to look at our banking system. The banks are 100% digitalized. You can stay in one village and withdraw money from another village. You don't need to go to Lagos or come to Abuja to carry out any financial transaction. Even the manner of the way we are doing so many things. The only thing that needs to be done is that if we put our mind to it, we can have digitalization of the judicial system. You know, the other time, the MBA, and it was equally on everywhere, where the roof of the magistrate court was leaking. That was in Anambra State, in Anambra State, and it's a very terrible thing. There should be greater and proper funding of the judiciary. I don't know, when I saw it, I asked myself, what exactly are we doing? Does it mean that there is no budget for all these things? And when you go back, you can see there are so many things that are going wrong. The courtrooms need to be very, 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 very adequately provided with all the needed infrastructure. Even when you come to FCT High Court, there are some courts that are purely digitalized. The one that I appeared yesterday, purely digitalized, everything. But let me shock you. That particular court, the judge was the one that personally provided for all those things by himself. And when you go through our rules, the rules encourages virtual hearing, e-filing, and so many other things. But these things are not implemented the way it should be. So there is need. There is the e-filing both at the Court of Appeal rules, High Court rules of various states, Federal High Court rules, and the Supreme Court. It needs to be implemented. We are ready. The only problem is that, can the system allow itself to function? The system is failing Nigerians, and it's equally affecting administration of justice, which is a very sad and unfortunate scenario.
All right. Mr. also alluded to the abuse of bail and remand processes. So this featured prominently in his speech. Can you shed light on how remand orders are sometimes weaponized politically in recent Nigeria's cases?
You know, the unfortunate thing about that is that you may have a problem with somebody, or you may have a problem with a big man. We know of a senator, I don't want to mention his name, when somebody abused him, because really, actually, the person abused him and insulted his wife. He went to court, got a remand order, and that remand order, it allows it to be renewed for another 14 days and allows it to be renewed for another 14 days. And technically speaking, with such a remand order, you can keep somebody 42 days in detention without trial and is sanctioned. This is a situation whereby we say where the holding charge is statutorily endorsed, which is very, very unfortunate. And again, when there is a case before the court, a criminal case, the defendant may be granted bail. But there are certain conditions. Some may be that the prosecutor needs to go and know the address of the defendant, and to equally get certain other information. At times, it is very difficult. If there are certain prosecutors in prosecution of cases that will blatantly refuse or make it very difficult for all those conditions to be met. For crying out loud, the prosecution is equally a party in a case, just like the defendant. And it should be the judge and the court officials who are supposed to verify the addresses of the defendant if granted bail. There are equally some judges and magistrates who, when they grant bail, make it very, very stringent. And with that stringent bail condition, you can see that the bail which has been granted to the person, and which, for a case which is ordinarily bailable, has been made very, very difficult. And when there is a stringent bail condition, automatically it means that there is no bail. Because a stringent bail condition means the person will still be in detention. So these are the things, because when a case is ordinarily bailable, like most of the cases where defamation is criminalized, some of the sections says that where defamation, you bring somebody under Cyber Crimes Act, that the case on conviction, the person should be sentenced to either 2 years imprisonment or something like that. But you can see they will make it very stringent when the Administration of Criminal Justice Act says that for any offense for which imprisonment is 3 years and below, that offense is ordinarily bailable. And when they say ordinarily bailable, what it means is that the condition for grant of bail need to be very simple in such a way that the person can meet it. You call a trader, you will tell a trader that he has to get a director of level 16 to stand bail for him. Where will he get the level 16 officer? Instead of telling him to go and get somebody, maybe a person of a standing within his own trading community, you are telling him to go and get a civil servant. Notwithstanding that the courts have severally held that it is wrong for you to go and tell a civil servant to even stand condition, to even stand bail for somebody as a surety. But it is still happening, and nothing is being done to address that situation. It's quite pathetic, I must tell you the truth.
But why do judges neglect what is written in the laws? Is it that they are ignorant of the laws, or they know about the laws, but they deliberately don't want to, abide by these laws?
Anyway, the truth about it is that the grant of bail is at the discretion of the court. The only issue is that, is this bail condition considered judicially and judiciously? It is on the basis of that, because it is at the discretion of the court, it allows the court certain opinion when granting bail, because they are the ones that set the benchmark. And by the benchmark, they are setting the conditions under which somebody is granted bail. And it is in setting that condition under which somebody is granted bail, that is where all these bail conditions, particularly some of them are times stringent. It's not that it is like that in all cases, but more often than not, the bail conditions are difficult. And when you now remand the person in prison when ordinarily he should have been granted bail on a very simple terms. It becomes a very big issue. It becomes a very big issue and infringes on the person's constitutional rights for presumption of innocence until proved otherwise.
Right. There is this commonly asked questions about bail. There is common phrase that bail is free. Bail is free. I don't know if you can shed more light on it. Is bail free in Nigeria? Because we always know that there are conditions behind it. So why is it said that bail is free?
Bail is free. Bail is free. What they mean is that once you meet those conditions which are attached to bail, that you will be released without payment of money. I must tell you, to a very large extent, in our courts, once you meet the bail condition, you will be granted bail without financial inducements. I can't remember the last time I come across a bail being refused because you failed to bring money. So to that extent, bail is free. But the place that bail is usually not free, although they say that bail is free, is when you go to the police. That is where even after they have granted you bail, they will say, okay, you have to do this or do that. Yes, it is unwritten, but usually people are made to part with money. Initially, it used to be so brazen that you will be told if you don't bring certain amount of money, you can't be released. But because of the cries of people and the activists, to a very large extent, the police are trying, but there is still very, very big room for improvement. So technically speaking, more so as it concerns the police, bail is not entirely free. And at that particular time, you will see that the police are not your friends.
Quite interesting. Now, the NBA president also emphasized that children should never be charged alongside adults in the justice system. Now, reflecting on the controversial 2024 arraignment of at least 32 minors, some as young as 14, who were detained and charged with serious offenses, including treason during the end bad governance protest. Now, how do you evaluate the Nigerian justice system's handling of juvenile defendants?
Incidentally, a child that is under 18 ought not to be tried. There is what they call a juvenile court, which ought to be established for the trying of such children. But incidentally, just like you rightly pointed out, in 2024, we saw the police arraigning children, minors, over 22 of them. In as much as we know very well that the law has provided how you know the age of children, but we are all parents. Where you see a minor, you will know. And on that particular day, we saw so many of them, and we are alarmed. They were kept in detention for months, which is unconstitutional, which is illegal. So, and the problem is that the juvenile courts that are supposed to be established, virtually over 90% of Nigerian states do not have the juvenile courts. And because of that, that specific provision in Administration of Criminal Justice Act, which clearly provided that there should be juvenile courts to try children below the age of 18, is not being implemented. And that is why you are seeing that situation whereby children who are minors are being brought to court to be tried with adults. And you know the implication of such. Sometimes, more often than not, it exposes these kids, because the essence of trying them in a juvenile court is a situation whereby they are to be kept separate. It is a situation whereby they are not further corrupted by the adults that are sharing facilities with them or sharing court stands with them. They are supposed to be tried entirely, because there are certain things a kid can do. You will say this is a kid, and on the basis of that, you can overlook it. And some of these things can be cured by counseling. But it is not like that with adults, where you will say that this particular person is an adult and ought to know what is right. The law is very wise in making that clear-cut demarcation, that juveniles, kids, minors will be tried independent and separately from adults. Sadly, we are not seeing that reality in Nigeria present, notwithstanding that we have adequate provisions of the law for it.
Right. Thank you very much. Move to Showere's case, which is very interesting. Showere called President Tinubu a criminal on social media and is now facing defamation charges. Of course, the court has adjourned the case, the commencement of the case to October 27, I think. So, do Nigeria's defamation laws protect people's reputations well enough without stopping people from speaking out politically?
In as much as I'm not a fan of what Showere said, but the truth about it is that there is now becoming a very thin line between crime and civil criminalization and criminalization of defamation and the civil aspect of defamation. We have seen so many times and so many places where these things are taking place. You know, granted, Showere called Tinubu without mentioning his name, or it has to be clearly stated. He didn't mention the name of Tinubu, but he clearly described the Nigerian president as a criminal. And he had his reasons. Ordinarily, it is not for DSS. It is not for the Nigerian authorities to go after him. If the president, for whatever reason, feels that his person has been defamed, a civil suit could have been the appropriate remedy. But incidentally, in Nigeria, they have criminalized defamation, notwithstanding that certain courts in Nigeria, particularly the Court of Appeal, has struck down Section 24 of the Cyber Crimes Act, claiming in the case of Olawoye against Federal Republic of Nigeria, claiming that it is grossly offensive, indecent, obscene, menacing, and injurious to persons for them to be tried for criminal defamation when ordinarily a civil action could have solved the problem. So as it concerns Showere's matter, I feel very strongly that the appropriate option open to the president would have been to institute an action against Showere in his person. Because the truth about it is that defamation is personal. It has nothing to do with another person. It has nothing to do with crime. But this particular thin line, which has been introduced, and it has even gone to the extent that nowadays, when you say one thing, either WhatsApp, TikTok, Facebook, they term it cyberbullying. It is wrong. We know that at times persons cross lines. The appropriate thing is to strengthen the judicial system, particularly in the civil cases of defamation. When you slam enough heavy cost on somebody, tomorrow they will not be in a hurry to go and say unsubstantiated things about another person. And if you feel very strong about what you are saying, that means that you are equally allowed to go and defend yourself. And if what you say cannot be substantiated and proved, you bear your cross. That is the way it should be. But that is not the way it is. Even under the present dispensation, there is a new act, Cybercrime Act, which has equally strengthened the criminalization of defamation, clearly trying to remove it from the civil angle for which it can adequately have been accommodated.
Yes, thank you for bringing up the current Cybercrime Act. Could you tell us the highlights of the act, what it intends to achieve, what it criminalizes, and what it holds to be a true criticism of government or anything?
The truth about it is that in Nigeria, there is what they call the Cyber Crimes Prohibition, Prevention, etc. Act 2015. And just like I pointed out initially, Section 24 has been used to criminalize online speeches because that is where most of these cases are. We have seen some governors that have abused it. We have equally seen El-Rufai in Kaduna did something like that in the past. The governor of Cross River, I think Cross River Akwa Ibom, when Abba Jalingo, the journalist, was equally on the basis of that put into detention for so many years, which could have been ordinary, because when somebody is alleging that certain fraud took place, instead of investigating and showing the person that nothing of such, the next thing is that they criminalize it. So that is exactly what is happening. Just like I stated before, ordinarily defamation is a civil wrong, which there are three remedies which can always cure it. One is apology, the other one is retraction, and the third one is damages. But more often than not, our criminal code and our Administration of Criminal Justice Act have technically criminalized defamation. But the truth about it is that the prosecution in most of these things are rare, because it is difficult when you look at it in line with the freedom of speech, which the Constitution allows. In as much as there is a boundary between your right to speech and that of defamation. So when you speak on the basis of your right, which you have to speak, and you speak wrongly, the law has provided a remedy in defamation for you. And if you extract it, that's why usually when such a person is defamed, the first thing you do is that you do a demand letter, wherein you ask the person, this thing you've said about me is not true. The first thing you have to do is that you will tell the person to retract it. The second thing is to apologize, and you can now follow it up with seeking for damages, or tell the person to pay you damages, certain amount of money. And if you don't pay it, the matter will now be taken to court. But you can see that that is not the issue. Just like you rightly pointed out, Showere has been charged under the Cybercrime Act for report and comments made against the president. And this charge, of which he is to be arraigned on the 27th, they tried to arraign him earlier in the week, I think on Monday, but it was not possible because he was not served. He was served in the courtroom. Then the matter has now been adjourned to 27th of October for proper arraignment. This particular one is a clear case of use of state power to suppress critical online speech under the guise of cybercrime. There is need for it not to be allowed to continue, and the Nigerian government is hereby urged to retract this step. If you feel that Showere has in any way defamed the president or defamed his standing, commence a civil action, like we saw Femi Falana when he felt he was defamed by a very dark man. He didn't go ahead to start doing petition to the police because he understood actually that the proper thing is for him to commence a civil action against very dark man, and which was what he did. So Tinubu can borrow a leaf from Femi Falana and do the what is right, commence a civil action against Showere instead of using the state power, the DSS, and some other things to intimidate him.
Is there not anything like criminal defamation? Because you said that defamation in whole has to do with the civil suit and has nothing to do with, harming other persons, but it is always personal. Now, don't you think it could have a way of, expanding the harm to other persons? For example, especially in political cases. For example, when this barrister Adeyanju, makes a statement against P2B, and it triggered a war between the obedience and the members of. So, don't you think there is a thing? Defamation sometimes could have a criminal element in it.
We understand that. Just like P2B too, because I forgot to give that as an example. You can see he didn't write to the police. He wrote directly to Adeyanju, telling him to retract, apologize for the things he has written. I must tell you that at every particular point in time, in as much as it is important that you protect your reputation, but at the same time, there is need to safeguard our democracy and free speech online. In as much, just like P2B did, if you feel for any reason that you are being maligned, I repeat, the most important thing for you to do is to seek civil action in defamation against the person that is maligning your name. That way, there will be a striking of balance between protecting your reputation and the safeguarding democracy and free speech. A situation whereby, for any reason, you say that you are criminalizing this free speech means that at times, when somebody insults you, the next thing you will do is that you will go and call police. There will no longer be that vulgar abuse. You can see some people will come and say, you are mama, thunder fire you. The next thing you criminalize it. Or God punish you. The next thing you criminalize it. Those things are mere vulgar abuses. And such things cannot be allowed to be criminalized. And that is where you get the strong men in the system. The next thing they will start asking you, do you know who I am? Granted, there is supposed to be a clear boundary. But what we are saying is that it is very dangerous. It is very, very dangerous for you to criminalize defamation. We knew of that early period of time during the era, the First Republic, Second Republic, when Jim Nwobodo, after being as the governor of Anambra State, Ato Nwankwo, an activist, wrote how Jim Nwobodo ruled Anambra State. He said so many things which Jim Nwobodo was not happy with. The next thing, they arraigned him in court. He was tried for sedition and convicted. But on appeal, that conviction was set aside. The court clearly held that on no condition can you criminalize freedom of speech. That the day you do it, because the beauty of democracy is that it allows you to say your mind. But when you are saying your mind, you must be responsible for whatever you are saying. And if for any reason another person feels that you've crossed the boundary, you bring civil actions you bring a civil action against such a person in court. So that is what it should be. Because any time you start to do that demarcation between criminalizing a decent opinion, then that is the time that we know that we are no longer in democracy. We are now in authoritarian rule.
All right, thank you very much. Now,
Okay.
electoral reform is ongoing, and many people are agitating and advocating for that if we must have a decent and malpractice-free poll come 2027. So what specific legal reforms could help reduce election-related litigation and post-election conflicts?
The truth about it is that I must tell you, I'm no longer enthusiastic about electoral system in Nigeria. Before 2023, when we started democracy in 1999, I saw the way things went. Under Maurice Iwu in 2003, it was terrible. In 2007, we thought that something can be done. Even the president, Yaradua, had to admit that the electoral system that brought him to power was greatly flawed. There was improvement in 2011 by Goodluck Jonathan. By 2015, some of the improvement was eroded. By 2019, at a stage, it becomes as if to say we are no longer whatever it is that we are doing. There tried to be improvement, but by 2023, everybody saw what happened. It equally made me to be very tired of our electoral system. When I saw the card reader, when I saw all the innovations that were put together by INEC, where they said it was a game changer, I went ahead preaching it, thinking that it was. But on the day of election, they introduced bleach, claiming there was bleach. Even when there were evidence from the Microsoft and so many other, all the companies that are involved, that nothing of such took place. Our courts did not believe it. And they went ahead to declare the election of the president substantially complied with the Electoral Act. And the INEC regulations was discarded. And we were told that we have to go back to voters register for us to have elections. The truth is that just like we are clamoring for digitalization of our judicial system, we are equally clamoring for digitalization of the Electoral Act in such a way that once you vote, it will count real time. The machines will be there for you to see who you voted, for you to see the number of persons that voted. If all these things are digitalized and computerized, it will substantially eliminate electoral fraud. And the next thing that will happen with the elimination of electoral fraud is that persons of greater quality will come into the electoral system, will come into the political system and try to be part of it. When you go and check, majority of those that are involved in election are people, majority of them are people that have questionable characters. The decent persons are staying away. The highest the decent ones do, more often than not, is just to accept appointment to see what they can do. I remember of a professor from Edo State. He was so pissed off that he started apologies for the language I used. He didn't like it, that he said that he even regretted being intelligent. That if he is not intelligent, if he was not intelligent, that maybe he could have done what others used to do to get political power. And it is the unfortunate scenario we are seeing in Nigeria. The decent men can't go into the gutter and play that game. And the only way to protect Nigeria, and that is why you see Nigeria keeps on going down and the down and the down and the down the drain. Unless there is an improvement in our electoral system and the system of appointing the chairman of INEC and the officers of INEC equally improved upon, we won't get to that political order anytime soon. And that will be quite unfortunate.
All right, thank you very much. Ifeanyi Nrialike, distinguished legal practitioner, consultant, and public commentator. It was nice to have spoken with you. I would wish to speak with you again next time on a different topic as things progress. Thank you very much for gracing this interview.
Thank you very much for giving me the honor to be here. I appreciate the opportunity for me to share my thoughts on some of the critical issues that are affecting Nigeria. And I hope that the authorities will have ears and listen to some of these our cries and do something about it. We have refused to leave Nigeria. We say we can make it better. And we pray that all our hope and aspiration to make Nigeria a better country will be put into consideration by our leaders. The only thing we are asking them, please be patriotic, love Nigeria. Because if you try as much as possible to be patriotic and you love Nigeria, this country is a very wonderful country. We are endowed, both human capacity, both material-wise, both natural resources. We have so much, and we can put it to use for the betterment of our country. And once we put it to use, the next thing that you will see is that poverty is eliminated. And once poverty is eliminated, crime is eliminated. Because it is poverty more often than not that is causing crime. And if people are trained, the resources we have is being put to train Nigerians, you will see that there will be an increased number of quality Nigerians. And by it, automatically, there will be elimination of corruption. There will be a better Nigeria. People will have very decent spaces to operate. I pray that our leaders should do something about it because it is heartbreaking. Thank you.
Right, have a nice day, sir. Thank you very much.
And thank you for having me once again.
Right, viewers, William will come to you again next week. I am Tosh Raphael. Have a nice day. Bye-bye.